So, good morning all of you, and thank you very much for coming in. As you all know that today we have a very eminent, one of the best legal minds in the country, Dr. Aditya Sondhi is with us. And when I spoke to Aditya sir on WhatsApp, and he readily agreed, despite of his busy schedule, he has to head towards Almora Literary Festival, as you all know, because of his magnificent publication of Poles Apart. So today, not saying much more, I welcome on behalf of my entire community of Vida lawyers. As you all know that we are periodically arranging these sessions and calling good luminaries with us so that they can come and share their experiences. So the topic which is being chosen today is a topic which is, shall I say, very closely related to all of us, because we day in and day out practice constitutional law. And the main mechanism and the scale to opt a remedy and devise something like rights, or if we made any pitch especially in High Court, so we need to understand the depth concept of writ jurisdiction, and nobody better else than sir who will elaborate on the concept, and thereafter we'll have an interactive session. If you have any problem practically, so you can directly interact with sir and you can have the answer. So before starting the session, I request my all honorable lady advocate members to stand together and present a bouquet of flower to Shri Aditya Sondhi sir.
Thank you very much. Thank you.
Totally a pleasure.
Shri Shakti Singh ji, learned members of the Bar Association, past and present, and dear friends from the bar, and of course young students who I believe are online. Thank you very much for this most generous welcome to your beautiful court and to your beautiful city. I have actually done a couple of matters along with Mr. Gupta here during the COVID days, but because of the restrictions on travel, those matters were done online. And today I have the pleasure of being on your campus, though without my robes, to speak to you on writ jurisdiction. I commend Shakti and his colleagues for having these sessions, because a lot of our learning, friends, happens, I think, outside of court as well. And to have a chance to brainstorm on legal issues and to exchange thoughts, I think, is extremely important. I'm sure you have many questions, so I will keep my introductory comments brief and then look forward to interacting with all of you on this. On writ remedies, the first thing that I want to say is that when judicial review is treated as part of the basic structure of the Constitution, at the heart of judicial review is writ remedies. So the entire gamut of writs that we seek against the state or agencies of the state really constitute the basis for judicial review by the courts. So right from questions of validity of provisions, और आपने देखा होगा परसों ही ऑर्डर आया था सेक्शन 6A पे ऑफ द सिटीजनशिप एक्ट, मैरिटल रेप पे बहस चल रही है सुप्रीम कोर्ट में. वो जो मैटर्स हैं वो एक एंड ऑफ द स्पेक्ट्रम पे हैं, जहाँ पे लार्जर क्वेश्चंस ऑफ कॉन्स्टिट्यूशनैलिटी, फंडामेंटल राइट्स, लार्जर पब्लिक इंटरेस्ट, legitimacy, competence, legislative competence, etc. come into question. But writ remedies जो हैं, they transgress many such aspects. So in a writ, you may seek enforcement of fundamental rights, you may seek enforcement of constitutional rights, you may seek enforcement of statutory rights, and again short of that, you may be in a writ petition alleging violation of first principles of natural justice and of administrative law. So in that entire spectre comes in this larger framework of judicial review and writ remedies. और उसमें आप देखेंगे between a challenge to the virus of a provision, right from say the constitutional validity of a constitutional amendment such as the NJAC. That was a constitutional amendment that was challenged in the Supreme Court and held to be violative of the basic structure of the independence of the judiciary and indirectly therefore of the concept of judicial review, वहाँ से लेके certiorari writs, mandamus writs, habeas corpus writs, quo warranto writs, they cover the entire spectre of writ jurisdiction. But each relief entails a certain element of the nature of rights that we are enforcing. And therefore, in our minds, we need to be very clear when preparing a writ. Of course, as a senior now, वो दिन गए जब हम ड्राफ्ट किया करते थे, अब ज़्यादातर सेटल ही करते हैं और बहुत बारी सेटल होने के बाद ब्रीफ्स आती हैं हमारे पास और उसमें कभी कभी दिक्कत भी होती है क्योंकि बहुत से पॉइंट्स हम देखते हैं वो मिस हो जाते हैं, फंडामेंटल पॉइंट्स, और मैं उनके बारे में आज बात करना चाहूँगा. बट उस स्टेज ऑफ ड्राफ्टिंग में, उस स्टेज ऑफ प्रेपरेशन में आई थिंक हमारे मन में ये पॉइंट्स क्रिस्टल क्लियर होने चाहिए कि हम किस टाइप की रिट रेमेडी इलेक्ट कर रहे हैं, किस कोर्ट में इलेक्ट कर रहे हैं, कैसा प्रेयर हम सीख कर रहे हैं उस रिट पिटिशन में और किस पार्टीज के अगेंस्ट वो रिलीफ हम कोर्ट से मांग रहे हैं. उसमें क्या होता है, वी कैटेगराइज, एंड आई फील दिस इज वेरी इंपॉर्टेंट, not only the array of parties but the nature of pleadings to be made in each case. अब आप constitutional validity का एग्जाम्पल लीजिए. It's really not a writ that you seek when it comes to a challenge to an enactment. And this is something the Supreme Court had said long ago in the 70s in a judgment. If I recall, the court said that we are pained to see that in many cases of challenge to the virus of provisions, the prayers are sought in the nature of certiorari. Certiorari is really judicial review. It's review of correctness of orders and proceedings of tribunals and authorities subordinate to the High Court. But in a constitutional validity writ petition, the prayer is really one of declaration. Declaration हम आमतौर पे एक सूट में अप्लाई करते हैं, किसी एक प्रॉपर्टी डिस्प्यूट में आप ले लीजिए फॉर ए डिक्लेरेशन ऑफ टाइटल. बट व्हेन इट कम्स टू ए रिट रेमेडी सीकिंग ए चैलेंज टू द वैलिडिटी ऑफ एन एनैक्टमेंट, आप सेक्शन 6A का एग्जांपल ले लीजिए. इन दैट द प्रेयर देन हैज टू रीड एज a declaration that section 6A of the Citizenship Act is unconstitutional and ultra virus and being violative of various fundamental rights in the Constitution, and a consequential mandamus to the state authorities not to enforce the said law. और इसी पॉइंट पे मैंने कई बार देखा है कि ड्राफ्ट्स स्टंप हो जाते हैं कि वो प्रेयर ही उस स्टैंडर्ड की या उस लेवल की नहीं होती. और ये सिर्फ एक टेक्निकल बात नहीं है, क्योंकि द प्रेयर दैट यू सीक हैज टू टाई इन विद द ग्राउंड्स दैट यू रेज. In a constitutional validity matter, your grounds necessarily must be either that the state or the center lack the legislative competence to make the law. For example, under Schedule 7, आपने मेरी बुक का जिक्र किया, उसमें एक चैप्टर AFSPA पे है. AFSPA was questioned in the Supreme Court and one of the grounds was the legislative competence of the center to make such a law. You'll be interested to find, though the validity of the act has been upheld by the Supreme Court, no doubt, but it's still a point for us to debate that the amendment to the 7th schedule introducing an entry providing for the military to provide aid to civil power came many years after the enactment of AFSPA. तो बहुत से nuanced questions आते हैं as to what is the source of power for a statute under Schedule 7. Is it traceable to list 1 or 2 or is it in the concurrent list? उस पे फिर अलग doctrines आते हैं of eclipse, of pith and substance, etc. मैं उसमें I'm not going into those substantive parts. But those grounds must then be clearly made in the writ. Then comes the second element, which is the consequential violation of fundamental rights for which a challenge is mounted to an act. And of course the third ground, which is really a ground within Article 14, that is of manifest arbitrariness of a legislation. But short of that, friends, you can always come to court and look, constitutional validity matters are not everyday matters. At least मुझे अपने करियर में जो हैं गिने चुने matters याद हैं जिनमें serious challenge हुआ होगा किसी constitutional validity issue पे, और उन matters में मज़ा भी बहुत है, but these are not matters every day. You don't go to court on a daily basis questioning the validity of an enactment. But the daily bread and butter litigation of writs is what? Is certiorari, where you are seeking a challenge to orders of a tribunal, say DRT का हो गया या Central Administrative Tribunal का हो गया या किसी और authority का हो गया, or you challenge the validity of a government notification, imposition of say section 144 under the old CRPC, or prohibition, or any other such action which restricts the rights of a party, or it could be even a licensing issue, a mining issue. Now in all those cases of certiorari, the thrust of course is on violation of certain fundamental rights. It could be 19(1)(a), it could 19(1)(g), it could be 21, it could be 14, but it is also often based on first principles of administrative law. And that's where I think when we prepare writs, we have to keep into element in our mind the elements of challenges in such cases. And therefore the amplitude in certiorari writs is actually much greater. It could be a violation of a statute or a statutory provision. Supposing a notification is issued by a person without jurisdiction, that's a straightforward ground for you to raise, and want of jurisdiction is a classic ground in writ practice. Or violation of natural justice for having not been heard or not been heard appropriately by an authority. Tax matters में ये बहुत बारी होता है. Or the fact that orders are unreasoned. You will appear before an authority or a tribunal, make elaborate arguments. You will receive a half a paragraph order with no reasons, with no reference to your submissions, no discussion on questions of maintainability, etc. That is a ground of natural justice, the absence of reasons, or of course bias on the part of the authority making that decision. Now friends, these take us across different aspects of the law. Constitutionality or constitutional law आपका शायद first segment में ज़्यादा आएगा, where you are challenging the virus of an enactment. But otherwise, I think for one to be practicing on the writ side, an engagement with administrative law is extremely important. And administrative law has been developed through precedent, through good commentaries, and also in some ways on first principles and tradition. And I think that's something we must build in. The good old Wednesbury principle, such a simple principle where an authority takes into account extraneous materials or disregards relevant materials. The barium chemicals judgment principle. It's a test that reminds us and it reminds authorities as to how they must act responsibly to restore faith in the administration of justice. This is why I made the point. Writs, these are not ordinary remedies. These are extraordinary constitutional remedies, and for a reason. It's not just a question of what rights are being enforced or what the outcomes are. When authorities and tribunals act in accordance with principles of natural justice, in accordance with principles of administrative law, act within their jurisdiction, act with reasons and a reasonable manner, the faith in the system is enhanced. Look, our justice delivery system is such that cases don't begin with writs. एक रिट में ओरिजिनल मैटर कब आएगा आपका? जब आप किसी स्टैट्यूट को चैलेंज करेंगे या आप एक पब्लिक इंटरेस्ट लिटिगेशन लगाएंगे, और उसके बारे में मैं कुछ बात करूंगा. बट बिसाइड्स दैट, इन ए रिट इनवेरिएबली you are coming to court after a round of litigation, or maybe multiple rounds of litigation, where you have been to an original authority, been to an appellate authority, and then filed a writ, by which time the decision making has already happened. And it is expected that that decision making is done in accordance with law. और इसीलिए आप देखेंगे कितने केसेस में मैटर रिमांड होते हैं कि ठीक है, मेरिट्स अपार्ट आपने ठीक नोटिस तक नहीं दिया एक टैक्स मैटर में, आप फिर असेसमेंट ऑर्डर कैसे पास कर रहे हैं? It goes back to authorities, and many times these orders, I am glad either make strictures or lay down binding guidelines as to how these authorities must act and exercise their discretion. Because a lot of these powers are quasi-judicial, and when quasi-judicial powers are being exercised by sometimes non-judicial persons, things can get out of hand. But friends, I want to also come back to the point as regards the importance of pleadings in writ matters, because there are many threshold barriers to be crossed in writs, which are very different from suits. There are a whole host of self-made restrictions or restraints basis which courts refuse to exercise writ jurisdiction. हम बहुत बारी सुनते हैं कोर्ट में एज ए रिस्पोंडेंट, मैं भी एडिशनल एजी रह चुका हूँ कर्नाटका का, और आप किसी भी स्टेट का काउंटर ले लें, उसमें पहला ग्राउंड ये होगा दैट द रिट इज नॉट मेंटेनेबल. बट आई हैव ऑलवेज फेल्ट a writ is not maintainable only in very extraordinary circumstances. A writ is in fact always maintainable because of the powers vested in courts under 226 or Article 32 if you are in the Supreme Court. But there are many reasons for courts not to exercise that jurisdiction. So want of jurisdiction and reasons for not exercising those jurisdiction are quite different. There can be a want of jurisdiction if you file in the wrong court, for example. ये भी मैं बहुत बारी देखता हूँ. Cause of action आपका नैनीताल में arise होगा, but because the respondent is the center, writ दिल्ली में file होगी. अब Article 226(2) very clearly says that the High Court may exercise jurisdiction in respect of an authority or a person that is situate outside its territorial jurisdiction so long as the cause of action arises within its jurisdiction. और ये onus हम पे है फिर as a lawyer to gauge the facts. और cause of action as you know is a bundle of facts. वो तो एक सूट में भी वो इशू आता है जब आप territorial jurisdiction चुनते हैं कि ये केस कहाँ फाइल होगा, और जब उस bundle of facts में predominantly cause of action यहाँ है, petitioner यहाँ है, violation यहाँ है, merely because the authority is sitting outside does not mean you have to run helter-skelter to file writs across the country. And that's one of the advantages of having the powers of 226, especially 226(2). Conversely, if you file a writ in the wrong court, simply because your client is here, but the effect of that order is not felt here, right? There is a lack of jurisdiction. But it is in cases like this that one may say a writ is not maintainable. Or let us say if you are seeking a remedy against a purely private party. This is a very interesting and emerging area. In Kaushal Kishore's case, the Supreme Court last year said that writs lie even against private parties when it comes to the enforcement of fundamental rights. But look, that's a very sweeping statement. And I am quite certain that in the years to come, Kaushal Kishore will be read maybe differently, maybe read down, depending on the circumstances. So if we return to first principles, if you are seeking enforcement of fundamental rights, that has to be necessarily against the state. अब आपको वो तय करना पड़ेगा आपके रिट में कि आपके रिस्पोंडेंट स्टेट हैं कि नहीं हैं. जब वो स्टेट गवर्नमेंट है या सेंट्रल गवर्नमेंट है तो बात बहुत आसान है. बट इफ इट इज say a statutory authority, also a statutory authority is state. But many times writs are filed against associations that may not be statutory. Recently I was doing a case with respect to the Football Association in the Delhi High Court. Now one of the questions could arise, is it state or not? That is if you are seeking enforcement of fundamental rights. और वहाँ पे tests अलग हैं. Deep and pervasive control of the state. अब deep and pervasive control prove करना उसका onus petitioner पे है. अगर आपके petition में वो draft नहीं हुआ, आपने ये नहीं कहा कि that the appointments to the respondent board are made by the government, that there are large tracts of land allotted by the government, the funding is controlled by the government. बहुत बार ये writs clubs के against file होती हैं. Golf association के against writ file हुई है बैंगलोर में, उसमें भी एक question आता है, is it state or not? And if you are unable to show that it is state, with the exception that I made of Kaushal Kishore. I think that law has been turned on its head, and we need to see how it plays out. But on first principles, that onus still remains. But that's not to say that a writ does not lie if it's not state. 226 में तो public authority का reference है, तो एक तरह से 226 32 से wider remedy है वो. We often think that the powers of the Supreme Court under 32 are broader, but it's the other way around. 32 is confined to fundamental right violations, number one. Number two, in a matter of practice, I will tell you, if you file a 32 petition in the Supreme Court, invariably the bench will say, why don't you first go to the High Court? So it's only in exceptional cases, आप ले लीजिए, which जैसे marital rape का issue है, larger public interest has a pan-India implication, or a case that I am arguing presently, where a particular accused has been foisted with complaints and FIRs in 6 states in respect of the same offence. You can certainly go under 32, read with the extraordinary power under 142, and ask for clubbing, quashing, etc. But as a rule of thumb, a writ petitioner is expected to first go to the High Court concerned. And that's where 226 becomes a broader remedy. Because even a public authority is amenable to a writ. And any discharge of a public function gives rise to cause of action. It need not be a fundamental rights violation in every case. But this nuance we have to build in and plead in our case. If you don't plead it in your petition, you don't show how the respondent is either state or it is a public authority discharging a public function, there will be a question of maintainability. But that said, coming back to the well-known criteria on which writ jurisdiction is refused to be entertained, I think again the onus remains on us as counsel to make sure that we tackle all of those in our writs. Now, one is of course the well-known exception of alternative remedies. Existence of an alternative remedy is a bar to a reason to refuse the entertainment of a writ petition. No doubt, it's a yeoman principle. You can't be running to the High Court in every case. But it is not just an alternative remedy, it is an alternative and efficacious remedy. And this efficacy of the remedy, I think, is very important, friends. बहुत बारी आप देखेंगे आपके पास रेमेडी होगी शायद सरफेसी मैटर में डीआरटी के पास जाने की, बट अगर डीआरटी की सिटिंग नहीं है या वहां कोई प्रिजाइडिंग ऑफिसर अपॉइंट नहीं हुए तो वो अल्टरनेटिव रेमेडी तो पेपर पे हुई, वो इट्स नॉट एफिकेशियस. इफ यू नीड एन अर्जेंट स्टे, वेयर डू यू गो? I see this in RERA matters, for example. Being a new tribunal, the appellate authority did not have a presiding officer for the longest time. Sometimes the administrative tribunals do not have appointments. So it may be that the jurisdiction lies with some other authority. But if that authority is not available or not sitting, then that remedy is not efficacious. Many times authorities require you to pre-deposit 75%. We have argued cases that makes the remedy inefficacious. It's almost prohibitive, and in some circumstances, based on the equity, courts have entertained. The other element of efficacy is you may have the remedy, but the authority or the officer concerned may already have taken a view on the matter. For example, tender matters में आप देखिए, जब आप टेंडर चैलेंज करते हैं, हमारे कर्नाटका में एक वो ट्रांसपेरेंसी एक्ट है, where against the rejection of a tender, appeal lies to the secretary concerned. Now, supposing the secretary himself or herself was part of the committee that rejected the tender, then the appeal is going, as Justice Kabir had said, from Caesar to Caesar's wife. It's not an efficacious remedy anymore because there is an apprehension of bias. The authority has already taken a view. Or let us say in a tax matter, there is a circular issued which is binding upon a commissioner, and the appeal goes to the commissioner. You are challenging the validity of that circular. How will you go and appeal before the commissioner? A, the commissioner is bound by the circular of the board. Secondly, the commissioner would not have the judicial review power, I return to that point, of say quashing a circular. And this is where, friends, I make that point that the onus is on us then to state in a petition as to why we are before the court. नहीं तो बहुत से matters as a matter of course आते हैं और फिर स्टेट गवर्नमेंट कहती है या सेंट्रल गवर्नमेंट कहती है कि रेमेडी है और वो डिस्पोज हो जाते हैं. अब उसमें क्या मजा है? दैट इज नॉट रियल रिट प्रैक्टिस. रियल रिट प्रैक्टिस वो है जहां आप कहेंगे जी हुजूर अपील है, बट इन XYZ रीजंस की वजह से दैट रिट शुड बी स्टिल एंटरटेन्ड. want of jurisdiction, breach of natural justice, these are well recognized exceptions to alternative remedy. Supposing you are challenging the jurisdiction of an officer to issue you a notice, a show cause notice, then even at a show cause notice stage you can come to a writ court and say, why should I be relegated to file a reply, go through the rigor of a proceeding, when on the face of it the authority does not have jurisdiction to issue it. That's a well known, but that is again for us to be aware of and argue. The other 3 points I believe relate to fair disclosures by clients to counsel and by counsel to courts in the course of their pleadings. One is the element of suppression of facts. Now a writ remedy being an extraordinary remedy, when facts, material facts are suppressed, the writ court, notwithstanding the merits of the case, can throw out a writ. Just last week I argued a matter where a party, in a very simple matter of mutation of a revenue record, challenged a mutation order in favor of the party I was appearing for, did not make my party or my AOR's client a respondent to the writ, which by itself I think is a sharp practice, misjoinder, non-joinder in this case, and worse still, did not disclose the fact that the petitioner had received a show cause notice and a hearing before the mutation took place. And suppressing all this, went to the court and said, my lord, order is passed, no hearing, no notice. Unfortunately, the authority or the counsel for the corporation maybe did not have instructions or did not have the record, did not point out to the court that there was notice, and that order came to be quashed at the back of the party I am appearing for. Now, in a challenge to that order, the substance of the contention is, writ is maintainable, no doubt, but it ought not to be entertained for rank suppression of acts. And courts have held for the longest time that not only is it a power, but it is in fact a duty of the court to throw out such petitions where the process is abused, especially when it's an equity jurisdiction. In a suit, you will be denied an injunction if you go to the court with unclean hands, if you suppress material facts, because it's equity at an injunction stage. At the main stage, it may or may not matter. If you have not produced something, the defendant will produce it. But in the equity jurisdiction, one should never suppress, and I personally believe these friends, never withhold the fact that your client has suffered an order previously. मुझे अभी याद आ रहा है, जैसे आज सैटरडे है, एक बार हमारी स्पेशल सैटरडे सिटिंग हुई थी कर्नाटका हाई कोर्ट में, 15 साल पहले की बात कर रहा हूँ. किसी एक आइस फैक्ट्री की पावर कनेक्शन ओवरनाइट डिस्कनेक्ट हो गई थी. एंड यू कैन इमेजिन इन अ रेफ्रिजरेशन यूनिट, इफ देयर इज नो पावर, द बिजनेस कोलैप्सेस. And we moved the court sat specially on a Saturday, and we had received a notice from the Pollution Control Board saying that you have some XYZ violation. We had replied to that notice. After the reply, there was no final order passed. Now my client was little edgy, saying, sir, should I disclose this notice? If I disclose this notice, the court may think I am a polluter. I said, you have to produce it. And we produced it, and the first thing the court asked me was, Mr. Sondhi, was there any background to this? I said, yes, my lords, I had a notice. My client replied to it, but it has not culminated in an order. Two things happen. One is the case is live for the court to give you relief. The second thing is you have not suppressed. Had I suppressed that notice, the court would have said, you don't deserve a hearing, forget a special Saturday hearing. If your unit is closed, that is your lookout. And in many ways, that lookout is mine as a lawyer. I should be able to advise the client. Clients बहुत बारी आपसे अजीब expectations भी रखते हैं. ये मत दीजिए, वो मत दीजिए. but that onus is on us. और उसमें मैं ये भी कहूँगा younger members of the bar और law students को कि ये रिट jurisdiction के आगे का सवाल है, ये आपकी credibility का सवाल है. आप किसी कोर्ट में अपेयर होंगे सप्रेस करके, मिसलीड करके, आपके क्लाइंट ने एक सिविल सूट फाइल किया है, आप रिट में उसको डिस्क्लोज नहीं करेंगे तो आपका ओपोनेंट आके ऑब्जेक्शंस में डिस्क्लोज करेगा. आपको क्या फायदा हुआ उसमें? ज्यादा से ज्यादा आपको एक इंटरिम ऑर्डर मिल जाएगा, बट अगली हियरिंग पे एक तो वो इंटरिम ऑर्डर डिसॉल्व हो जाएगा, दूसरा आपकी फेस वैल्यू पे बहुत फर्क पड़ेगा. और वो रिट में नहीं, वो किसी भी प्रोसीडिंग में, किसी भी कोर्ट में मायने रखता है. एंड आई विल टेल यू फ्रेंड्स, if you are straight up with the court, you're frank with the court, courts appreciate it. It's good for you as counsels. It's good for your clients also. And if you're not, that word spreads. And trust me, that stigma then is very difficult for you to ward off. I've always said we should be in a position in court where court should take your word for it. आप जब facts narrate करेंगे कोर्ट को, the court should not be checking कि पेज 64 में वैसा डॉक्यूमेंट है या PW6 ने वैसे कहा है. If the counsel says it, it should be true. But that onus is on us as counsels. The other couple of things are, of course, latches. Many times writs are filed with inordinate delay. Especially you will find in land acquisition matters. A challenge to an acquisition sometimes comes 20, 30 years later, which could be barred not on any principle of limitation, but barred on the principle of latches. And we have to remember that latches and limitation are two different things. You see, limitation is a cut and dried principle. In a suit, you can go to the civil court on the last day available to you, and your suit is maintainable. It cannot be dismissed on the ground of limitation, even if you are just one day before expiry. But latches is a principle of equity. In a tender matter, if you are challenging the award of a tender, say of a construction of a bridge or a road, if you let the work begin, you let the party invest money, you let third party contractors be appointed, and you go to the writ court after 1 year, the court will say, sorry, you are barred by latches. It's not that you're barred by limitation, but your conduct in letting third party rights be created, or your conduct in sitting on the fence will be held against you. Many times in such cases, even a few days matter. आप एक demolition matter में अगर 1 महीने के बाद जाएंगे तो कोर्ट कहेगी आपको क्या चुप नहीं रहा था ये? If your property is being demolished, why have you come to the court 1 month later? You should have been at my door that day. So this urgency, I think, again is extremely important. We have to wait on the facts of the case, and in some cases that delay must be suitably explained. It can be explained. If you have been agitating before some other authority, or there has been some intervening judgment, etc., that must be pleaded. If it is not pleaded, out you go on latches. And one other point, friends, is disputed questions of fact. I think this is also very important. बहुत बारी कॉन्ट्रैक्चुअल मैटर्स में रिट्स फाइल हो जाती हैं. आपका कोई एडवर्टीजमेंट कॉन्ट्रैक्ट है, उसमें आपकी पेमेंट नहीं हुई, या आपका कोई कंस्ट्रक्शन कॉन्ट्रैक्ट है. मे बी द रिस्पॉन्डेंट इज ए कॉर्पोरेशन और इज स्टेट, बट if the matter involves adjudication, involves appreciation of evidence, involves detailed examination of a contract, then a writ would not lie. But at the same time, you must be aware that the Supreme Court has held, when it comes to admitted dues of a party by the state, then a writ is available. There is no reason you should be sent to the civil court or to an arbitration. Supposing a corporation has certified an amount due to your client who is a contractor, that's an admission of liability. There is no reason then that a writ should not be entertained, because you may be able to argue that there is a larger public interest in the project that your client has implemented, that the money is admittedly due, and no purpose will be served in moving any alternative authority like an arbitrator or the civil court. And lastly, friends, the point on locus, I think this is important. Many times writs are filed by parties who are not directly aggrieved, and this is a ground to refuse a writ petition. As I said, it's a self-imposed restraint, which is locus, the want of locus standi in a petitioner. And this is where I think we have to contrast a writ remedy with a PIL remedy. A PIL is also a writ. A PIL is also a 226 or a 32. But the contours of a PIL, the contours of a writ are very different. I don't have time enough to go into the elements of what a PIL should have, should not have, etc. Maybe we'll talk about it some other time. But on first principles, the doctrine of locus is what determines whether a case is a PIL or a private writ petition. And if a private writ petitioner is not aggrieved by an action, then the question of using or abusing a writ remedy would not arise. And there are many cases I have seen where people file writs, kahin pe kuch ho raha hai, as a busy body, you bring a writ petition. Now, if you are not aggrieved by the order does not affect you, the person aggrieved has not challenged it, a writ would not lie. It's a different question whether a PIL would lie in those circumstances. Simply because a party does not have locus does not mean he or she can file a PIL. In a PIL, you have to still show a larger public interest. You have to show that you are acting bona fide. You have to show that it's not a political or a publicity or a private interest litigation camouflaged as a PIL. So that takes me to the other area of drafting in PILs and how important those factors are. But you must pay heed to whether the client you are representing in the first place is a person aggrieved or not. And if the petitioner's locus is missing, then that becomes a ground for the writ court to refuse. I think with that I will stop and take questions from all of you.